Hello everyone, today we will be discussing a few cogent points on the hotly debated and discussed topic in the legal industry, the suspension of the insolvency and bankruptcy proceedings for a period of 6 months extended up to a year. The amendment ordinance was promulgated by the President of India on 5th of June 2020 in the backdrop of the Finance Minister's press release dated 24th of March 2020 giving out the tax and regulatory compliance package in the wake of COVID-19 and its far-reaching effects on the corporate sector. In order to safeguard the business from the far-reaching effects of the pandemic in the corporate sector, the amendment ordinance inserted a new Section 10A. Now let us have a look at the key highlights of this new Section 10A. This new section provides that no application under Section 7, 9 and 10 of the IBC shall be filed against a corporate debtor for a default committed on or after 25th of March 2020. Interestingly, the amendment ordinance also provides a proviso to Section 10A which states that no application shall ever be filed against a corporate debtor during this period, which is the period from 25th of March 2020 until the IBC proceedings remain suspended. For avoidance of any doubt, the amendment ordinance also clarifies that any application filed against a corporate debtor prior to the period of 25th of March 2020 shall be maintainable. Although the amendment ordinance has its advantages to protect the economy from falling into a domino effect with these force majeure events of default as defined by the Finance Minister, the amendment ordinance also comes with a lot of interpretational issues. Firstly, the amendment ordinance remains silent on the maintainability of the applications filed and pending prior to the date of its promulgation, but after the date set for force majeure default, which is 25th of March 2020. This issue was dealt with by the NCLT Chennai in the matter of Siemens Gamesa, wherein the NCLT Chennai concluded that the amendment ordinance shall have retrospective applicability to all applications that are filed on or after 25th of March 2020 under Sections 7, 9 and 10 of the IBC. This stand appears to be contrary to the judgments of the NCLT Chennai and the NCLT Kolkata while dealing with the issue of retrospective applicability of the amendment to the threshold to IBC, which was increased to 1 crore this year, in the matters of Aeroline Private Limited and Fresco versus Buesco, wherein it was concluded that in the absence of a specific mention to retrospective applicability, the amendment ordinance shall not apply retrospectively. Secondly, the amendment ordinance does not deal with the issue of applications against personal guarantors, which has now come into effect from 1st of December 2019. This issue remains crucial as banks and other financial creditors which remain at a standstill may now attempt to file applications against the personal guarantors. Thirdly, since the main objective of the amendment ordinance is to provide relief from financial distress to the corporate debtors, it may not be a viable option to suspend voluntary insolvency proceedings under Section 10A, forcing corporate debtors to remain in existence and to continue suffering losses. All these interpretational issues remain to be answered as and when challenged before the Supreme Court and the NCLAT. However, in the meanwhile, what is required from the legislature is to provide a clarificatory amendment to this ordinance.